Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator and Lead Recording Secretary for the Indiana Assembly. And we are continuing with Brent Allen Winter's Declaration of 76, United States Constitution, a common lawyer comments, clause by clause. And where we are ready to start this week is Article 3. Section 1, Clause 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office. Comment. Jesus Christ never refuted Israel's Supreme Court of last resort called the Sanhedrin. The word supreme is here obviously a comparative and not a superlative. Indeed, the U.S. Supreme Court is under our Constitution. This judicial power clause accords with our common law, giving federal courts independence from both Congress and the President. Also, our Constitution nowhere grants life terms for judges. It says instead that judges shall hold their offices during good behavior, meaning that unless duly impeached and convicted, a federal judge can stay on the bench for life if Congress has granted in any case a life term. Significantly, our Constitution never requires a certain number of Supreme Court judges. At least one, however, is required. Magna Carta Clause 45 defines the phrase good behavior with two requirements. We, King John and his successors, will not appoint justices, constables, sheriffs, or bailiffs who do not know the law of the land and mean to observe it well. California's Supreme Court says Magna Carta's Clause 45 is common law's demand that the judge overseeing the trial of a defendant facing jail must know the law. The principle we announce today is not novel. It dates back at least to 1215 and Magna Carta 45. 12 Cal 3D 323 334 1974. Indeed, such knowledge of the common law and the conviction to follow its course is gotten only in the real litigation. Thus, presidents and senators must allow only well-seasoned private practice trial lawyers on the federal bench. Nowadays, however, more and more judges come to the bench from government and mind-muddling academia, having had little to no struggle in the real practice of law. Such judges ever more promote state power at the cost of protecting private relationships and the rights of the individual, the only real rights. Increasing the number of judges appointed from government employment instead of the practicing bar threatens the independence of our judiciary and magnifies the significance of the Supreme Court's phrase, lone employee of the state. Contrary to the spirit and custom of our common law, career government hirelings for judges hold a dangerous bias toward government and against others. That we are not to draw judges from the ranks of government attorneys, but from lawyers in real practice, has been an unwritten requirement of the common law, basic and needful to the protection of both private rights and public liberties. Private law is the soul of the common law. The opinions of England's Court of Common Pleas established the character of common law by laying its foundations of private property rights and contract relationships. Nowadays, lawyers in common law countries who make their livings in independent practice before our courts are dwindling. To be sure, even in common law countries, a few judges have always come from the ranks of government attorneys. Nowadays, however, government attorneys dominate our court benches by over 60%. An important change is taking place in where judges come from. In the Eisenhower administration, roughly 65% came from the practicing bar, with 35% from the public sector. Today, the numbers are about reversed, but a judiciary drawn more and more from only government employees would not be the sort of judiciary which we have depended to protect the rule of law in this country. Brett Allen Winters, Excellence of the Common Law, subsection 632, quoting Chief Justice Roberts. Article 6 of our Constitution repeats Magna Carta's phrase, law of the land, which at bottom means, says the Supreme Court, common law, due process. Thus, any judge that ignores genuine due process fails to fulfill this clause standard of good behavior and must be removed. Bottom line, a congressman need be quicker to impeach a judge that ignores common law due process than he is to impeach a judge for being drunk on the bench. A drunken judge trying to follow due process is better than a sober one trying to overthrow it. This judicial power clause encourages each judge's independence of judgment. He need never fear any threat of dismissal for ruling against a president's desire. Indeed, if presidents could dismiss federal judges, judges would all become yes men, i.e., patsies for the president. That the judges both of the Supreme and inferior courts shall hold their offices during good behavior means that as long as a Supreme Court justice or federal judge desires to hold his office, he can as long as his behavior is good. If not, Congress can remove him from office by House of Representatives impeachment, followed by Senate trial, and convicted of treason, bribery, or other high crimes and misdemeanors. U.S. Constitution, Article 2, Section 4, Clause 1. This compensations clauses rule that a judge's salary shall not be diminished during his continuance in office, protects him against pressure from Congress, which could otherwise threaten to fix his pay low enough to tempt him to thwart the law for more pay or force his resignation. Note well, however, the clause never confines this prohibition to Congress. By a fair reading, it forbids any person from diminishing the pay of federal judges. Hence, if any person or combination of persons in government or outside it, by direct or indirect means, gains the power to diminish the pay of federal judges and does so, then that person or persons has violated our Constitution, has gained potential control of the federal courts. At common law, it is unlawful to do by indirect means that which the law forbids to be done by direct means. Therefore, to diminish the pay of federal judges or any federal judge by indirect means, as the Federal Reserve bankers now do, devaluing our currency through inflation by unconstitutional printing of paper, securities, and manipulations is unlawful. C 532 U.S. 570 2001. In fact, with each passing year, the Federal Reserve Bank Board, by such machinations, diminishes judges' pay. On 15 February 2007, Supreme Court Justice Stevens said that in his 30 years on the court, morale amongst federal judges has never been lower. The reason, he says, is low pay, which now threatens the independence of judges. A federal district court judge's yearly salary is $165,200. An appellate court's judge's is $175,100, and an associate Supreme Court justice is $203,000. When Congress set the foregoing pay for the federal judges, it was high enough. Though these salaries appear to have remained unchanged, they have dwindled in worth. Inflation has diminished them in violation of this judicial powers clause. Popular speech calls this deflation of worth inflation, giving the false impression that the central bankers' devaluation of money by their government-enforced monopoly over money is uncontrollable. By tampering with monetary standards for unjust gain, a few bankers diminish the pay of federal judges, which, as Justice Stevens suggests, now threatens the independence of our federal courts. Thus do chiselers oppress. That these bankers devalue every person's money the same is no justification, because the fact remains: the central bank's manipulation of the worth of money has diminished the worth of federal judges' pay, decreasing their purchasing power. Thus, it is unlawful to diminish by direct or indirect means the pay of federal judges, as now occurs. See further this handbook, U.S. Declaration of 76, Section 11, U.S. Constitutional Article 1, Section 8, Clause 5, and comments discussing the bankers' monopoly over currency and their manipulation of its worth. Section 2, Clause 1. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors or other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between a state and citizens of another state, between citizens of same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign state citizens or subjects. Comment: Matthew 11:12. Steadfastly forceful men take the jurisdiction arrangement of the skies by force. Romans 1:18. Truth is buried, adversity needed to unearth it. 1 Corinthians 11:19. Differences needful so that the truth shows itself. This real case or controversy clause sets forth two threshold requirements for a plaintiff to get his case into a federal court. First, the case must arise under this Constitution. Second, it must be a genuine controversy, disagreement between two or more parties. By requiring controversies, this clause enforces common law's requirement that the initiator of a legal action must be a bloody plaintiff, as opposed to a litigant merely anticipating injury or seeking legal advice from the court. A real controversy, says Chief Justice Hughes, is not merely hypothetical, academic, or moot, but is instead definite and concrete, real and substantial. It is distinguished from an opinion advising what the law would be upon a hypothetical state of facts. The common law says Justice Stone is the law of the practitioner rather than the philosopher. Thus, it is every man's law. The right of the federal courts to handle cases arising under this Constitution is the basis of the Supreme Court's jurisdiction to hold legislation of Congress unconstitutional. Chief Justice Marshall's 1803 opinion, Marbury v. Madison, recognized the Supreme Court's duty, when injury is shown, to review Congress's legislation for lawfulness. Further, the foregoing clause puts all cases of admiralty and maritime jurisdiction under the federal judicial power. Admiralty law is a form of civil law, good and necessary when confined to its proper use to govern shipping, ships, and those activities, and men in direct relationship to these, but downright dangerous when allowed ashore, the gist of many complaints in our Declaration of 1776. For instance, our Declaration cites British denial of the right to trial by jury by moving prosecutions of colonists to civil law's admiralty tribunals, which has no jury. Never forget, if trial is not by jury, it is by government. See U.S. Declaration of 76, sections 15, 20, 22. Admiralty being a civil law jurisdiction uses no jury. Britain's attempt to govern the American colonies using admiralty civil law and not common law deprived the colonists not only of trial by jury, but also of the individual right to keep and bear firearms, and of protection against arbitrary searches and seizures. Such British trespasses combined to rouse the colonials to armed resistance. See Brent Allen Winter's Excellence of the Common Law, subsection 310.3, discussing James Otis and the writs of assistance. In our own day, the general government is stretching, as did the British just before American secession from Britain's empire, admiralty and maritime jurisdiction between its authority, abusing Congress's statutory phrase, navigable waters, to reach far-fetched interpretations. Curiously, where the Admiralty Clause does bestow clear-cut jurisdiction to the general government, it often does not act, refusing, for instance, to take control of the 2010 Gulf of Mexico drilling platform explosion results. Early on, under the principle that federal jurisdiction, though limited by our Constitution, is nonetheless full within those limits, the federal courts held that the Admiralty Clause gives the general government jurisdiction over any ship and its crew steaming under the American flag, territorial ocean waters navigable by ocean-going ships, and navigable inland waterways, even if only with a dugout canoe. A reasonable interpretation. However, Justice Story's zeal for Admiralty jurisdiction stretched it even further. If Justice Story saw a corn cob afloat in a bucket of water, said one frustrated lawyer, he would take Admiralty jurisdiction over the bucket and the cob. Those agreeing with Justice Story later argued that Congress's phrase navigable waters embraced waters that one could make navigable by adding water through altering the shape of the channel that confines the body or trace of water in question, or by damming or dredging it. Thus, the feds now say that navigable waters includes not only waters that could be made navigable, but also tributaries to those waters. All the land that drain into or could be made to drain into those tributaries, and all spots within that drainage basin that become moist at any time or season, wetlands regardless of size. Using this open-ended definition, the feds justify jurisdiction over all moisture within and under the Earth's atmosphere, removing our Constitution's limit on federal power by transforming constitutionally limited admiralty jurisdiction into an unlimited power, thereby subverting the chief purpose of our Constitution to limit the jurisdiction of the general government. Thus, misusing the Admiralty Clause, the general government grabs power over all of the foregoing, in effect denying trial by jury to those seeking redress under the Takings Clause, U.S. Constitution Amendment 5, for government taking of property rights. Nowadays, Admiralty jurisdiction is said to extend even further than Justice Story's water bucket and corn cob, reaching on through to the fellow having tossed the cob into the bucket, taking jurisdiction over the cornfield from whence hence the cob came, the well from which he drew the bucket of water, and the entire aquifer and drainage basin that feeds the well, in short, the entire continent. Some insist that the general government will never succeed in depopulating our river valleys under such false assertions of the Admiralty Clause. Such folk, however, forget that the general government did just that when it designated and depopulated, for instance, the present Shawnee National Forest of southern Illinois along the Ohio River bordering Kentucky, the vast territories of the Tennessee, Colorado, and Columbia River drainage basins. Moreover, in recent years, the general government, in contempt of the common law of property of overstretching the Admiralty Clause, has taken vast tracts of Mississippi bottom farmland and damp places across the Midwest. Amendment 11 modifies this clause, setting aside the phrase between a state and citizens of another state, and removing from federal courts suits by citizens against a state except if by under Congress's permission to allow suit against the government has been by common law writ to the court with the words, let right be done. All right, that is the reading for this week, and I will see you on the next call, and peace and love.